A loved one has died. What do I do next? Hi, I'm Darren Findling of the Probate Pro, and we're going to discuss this very emotional and sensitive and important discussion because oftentimes people have no idea what to do after somebody has died. There could be many legal implications, and really there is no guidebook that tells people how to handle the affairs of an individual after they have died. Well, of course, first we have to address things like funeral, burial, cremation. So working with a funeral home or cemetery to address those important considerations. Now, with those decisions, there are people under Michigan statute that have priority to make those decisions. So it's important to understand that you may be the closest in connectivity relationship, but you may not have the highest order of priority to make the decisions regarding funeral, burial, cremation. So again, consult with an attorney to make sure that you've got the highest order of priority. After those issues are addressed and you've had some time to mourn and breathe, then we start addressing some of the technical legal things. And with a call into a law firm like ours, the first question is, well, do I need probate? And this determination is dependent upon the nature and extent of the assets that the person owned at the time of their death. For example, if the person died with just a small amount of assets, maybe a car and a little bit of money in a bank account, oftentimes we can avoid probate altogether. There are short form processes that are available to get, for example, a vehicle retitled into the descendant's name, as well as a small bank account. There are affidavit or small probate processes that allow us to get that money out of the bank account and into the family, the survivors, without the necessity of probate. So we want, as best you can, to determine what types of assets the people held, approximately how much, and whether they were only in the decedent's name. For example, a life insurance policy that has a named beneficiary. The named beneficiary can simply apply to the life insurance company to have that money released. In addition, a joint bank account. A joint ownership allows the survivor to go into the bank and pull the money out. These are considered non-probate assets. On the other hand, if an asset is owned by the individual, for example, a house or a large investment, or sizable investment, we should say, and there's a need for probate, the next question is, who has the highest order of priority to be able to serve as personal representative? Typically, it's the person named in the will, if there is a will, and if there is no will, it is then according to the laws of EPIC, the Estates and Protected Individual Code, that gives us a prioritization for purposes of the appointment of the personal representative. That personal representative has the legal authority upon appointment by the probate court to then handle and administer the affairs. Oftentimes people think that because they were named in the will, or maybe they were told by the decedent that they wanted them to handle their affairs, that they are anointed. And that's simply not the case. The process occurs through a very defined process of probate that, I'm reaching over to get the probate code, is defined in this book that details the steps and processes pursuant to the statutes and court rules in Michigan to guide you through the probate process. Now, we strongly urge you to work with a skilled, competent probate practitioner. At the Probate Pro, we can guide you through this. We can help you evaluate whether there is a need for probate or not. We can guide you through the probate process and address any questions that you may have. You're welcome to call us at 833-PROBATE or visit us at theprobatepro.com.